My name's Vicky Bowles. For those of you that don't know me, I'm a partner in our commercial team here at VWB, but I specialise in all things information law, and Claire, my colleague who's also speaking today, is a senior associate in that team. So we work in the commercial team, but we do everything that relates to information law for everyone across the firm, including our charity clients. Could I have the next slide, please, Ellie? So it's 5 years since the GDPR came into force, and what a 5 years it's been. Certainly my workload has increased, I don't know about other people. And so today we're just going to look at what's kind of changed over the last 5 years, and in particular what we've learned from ICO enforcement, some key lessons from the ICO guidance that's come out over the last 5 years, how to make dealing with rights requests easier because they continue to be problematic for clients in lots of ways, some top tips for avoiding a data breach, and then finally Claire's going to do a little section on reform of data protection law and talk to you a little bit about the new bill. As Ellie mentioned, any questions, do pop them in the Q&A box and we will pick them up. There'll be some time for questions at the end. Could we have the next slide, please, Ellie? So in terms of ICO enforcement over the last 5 years, we're now starting to see the enforcement under the UK GDPR and the EU GDPR as it was before Brexit, which is good because immediately after GDPR came in, the ICO was still dealing with a lot of cases that were being dealt with under the old law, so the penalties were different. But now we're starting to see all of the ones that are under the new regime and the higher fines, etc. And the ICO has been very clear throughout that they will take proportionate action. So what that means is that they will look at the type of breach that they're looking at if they're enforcing. They will look at the type of organisation, the effect that the breach has had on individuals, and they will try and pitch their fine accordingly. And importantly for charities, they do take account of the fact that you are a charitable organisation, and therefore a financial penalty, however large, for a charity is a much bigger or more significant, has a more significant impact on the way you operate than it would in, say, a commercial context. And the ICO has a range of potential penalties, but of course the ones that we usually hear about are the fines, and that's at the most severe end of the range. But they can do things like issue notices requiring you to make changes. And there are some other, there's the potential for prosecution as well, but I'll talk about that in a second. So looking at the fines, as a general rule, the fines that have been issued under the EU GDPR and now the UK GDPR are generally where organisations have not put in place security measures or there's been a breach of PECA. PECA is the Privacy and Electronic Communications Regulations. And those are the regulations that say that if you're sending direct marketing, so anything that is promoting the aims and ideals of your organisation or selling goods or services to individuals, if you're sending out emails or making telephone calls about that, you have to have the individual's consent before you can do that. For charities, that's pretty much a blanket, you need consent. There are very few opt-outs, unfortunately, at the moment for charities. So it's those two key things that it's really important to look at and assess and decide actually where is our, are we at risk of a fine because we don't have these things in place. 3 fines have been issued to charities over the last 5 years, and you're probably all aware of them, but I'll just mention them quickly anyway. There was HIV Scotland, who had a fine because they didn't have appropriate technical and organisational measures in place to protect personal data, and that was where an email containing some really sensitive personal data had gone to the wrong people. And again, the ICO looked at the fact that this was a charity, but the highly sensitive nature of the information and the potential risk to the individuals were factors that were relevant in terms of whether a fine was appropriate. And they also looked at the fact that there were sort of basic technical and organisational measures that weren't in place. I'm going to talk about those a bit later when I talk about how to avoid a data breach. Mermaids charity, again, that was lack of technical and organisational measures, and again, and it's particularly true actually in this sector because you do deal with very vulnerable beneficiaries, and again the type of information that was released there led to the fine. And then finally there was the I can't read my own writing, Global 1205 or 205, whatever they were called. And that was to do with unsolicited email marketing. So that was that breach of PECA. And again, that's where the fine went. There have been a few prosecutions under the Act, and that's where the ICO pursues director disqualification for breaches that are related to GDPR. They tend to be directors who have deliberately done something to release personal data, or they've taken action individually that's caused a breach. So it's not the organisation's fault because they don't have the technical and organisational measures in place necessarily. It's that an individual deliberately flouts those in order to do something that they shouldn't. But it's just important to notice that there have been more recently. So obviously the ICO, I guess, is getting their head around that power and starting to use it more often. So the key takeaway really for me in terms of the advice I give to my clients from that section is actually you do need to look at your technical and organisational measures that you have in place, and security is not just an IT problem, it's an everyone problem. And because the GDPR talks about technical and organisational measures, it's not just talking about IT measures, it's the organisational bit that you also need to be aware of and putting those things in place. But I'm going to talk in practical terms about what those are a bit later, but also making sure that your marketing is as good as it needs to be. Now, again, the issue of consent is a really difficult one because it can be difficult to get consent, and you need to, in order to fundraise, for example, it's really important that you're able to contact potential donors and build those relationships and get those funds in. So it's about analysing the risks of doing that in a non-compliant way and looking at the benefits of what you're doing as against the risks of potentially breaching PECA, etc., and working through where your risks are and making sure that you've minimized those as much as possible. So that's all I'm going to say about ICO enforcement. So I'm going to pass you over to Claire now to talk about ICO guidance. Could we have the next slide, please, Ellie?
Thank you, Vicky. Good morning, everyone. Thanks for joining. So over the last 5 years, we've seen quite a large volume of guidance from the regulator, from the Information Commissioner's Office. Such a large volume that I can't possibly cover all of it this morning in the kind of the 10-minute slot I have here. So instead, I wanted to pick up on a few key themes. Also worth reminding everybody that the ICO's guidance does not have the same status as law. It's not the same status as the GDPR itself and as the Data Protection Act, but it is really helpful because there are quite a few areas of legislation where there are kind of gaps, or there might be grey areas, and it's open to interpretation. And that's where the ICO's guidance really comes handy. Again, being the regulator, as Vicky's described as well, it's worth knowing how they are interpreting things, because that then helps you to work out how best to comply. And also allows you to work out where the riskier areas of compliance are as well. So it's quite useful just to have an idea about where the ICO are focusing, for example. First thing I want to mention regarding ICO guidance is their emphasis on accountability. So by way of a reminder, the accountability requirement under the UK GDPR says that not only do you have to comply with the UK GDPR, you also have to be able to demonstrate your compliance. And this was one of the key changes that we saw under the GDPR. So the Data Protection Act 1998, the predecessor, didn't have this same emphasis on demonstrating your compliance. Now, the ICO are very keen on the accountability requirement, probably because it helps them regulate, I would imagine. And they have created some very useful guidance around accountability, notably something called the Accountability Framework. Now, one of my favorite bits about this framework is that it makes it very clear that there is no such thing as a one-size-fits-all approach to accountability. And even within the charity sector, you know, when Vicky and I are advising our charity clients, some charities are quite small, some charities are much larger, some charities are doing things that are quite risky with data, some aren't. So when we're thinking about accountability, it's about thinking, how do you make it work best for your organization, for your charity? So whilst the ICO have suggestions about how you can do that, really it's up to you to make the accountability principle, the accountability requirement work for you. One of the key points as well is to think about how you are stress testing the measures that you have in place to comply with the law. So the ICO are very keen on the effectiveness of the measures that you're putting in place. Data protection impact assessments also really fall under this limb around accountability. So whenever you are thinking about doing any processing of personal data that's likely to lead to high risk to individuals, it's a legal requirement to do a data protection impact assessment. And the ICO, again, very keen on those assessments. Essentially, you are looking at what is the risk that arises to individuals from the processing you want to do. And then you kind of work through all the data protection compliance angles and work out how to mitigate those risks. Another key part of accountability is staff policies and procedures. And I'm sure Vicky will touch on staff policies around information security a little bit later on as well. Also think about where you need to keep records of your compliance. So again, we're demonstrating that compliance with data protection law. So for example, records of training that you've done. Records of information that you maybe have shared with the police, for example, if they've requested information from you, that kind of thing. There is also an obligation under data protection law to have a record of processing activities. And we would also recommend having things like a retention schedule as well. And these are all things that the ICO kind of cover off in their guidance. So it's very clear that the ICO are keen on you having this documentation in place to comply with the law. There's recently been a focus on the riskier processing activities of organisations. So when the GDPR first came in, the ICO were very much focused on what are the essential requirements of data protection law. But I've kind of noticed over the last maybe 18 months, now that that kind of bedrock of essential guidance is in place, they're focusing their attention more on the riskier processing activities. So we've recently seen, for example, them update their guidance on artificial intelligence. Particularly to take into account what risks that artificial intelligence poses to individuals. They also did some guidance recently on health data of workers. Other areas where they're kind of focusing, they're doing quite a lot around children. That's definitely an area where the ICO focuses their attention. And you can see that these issues are relevant to charities, because if you are processing the data of vulnerable individuals, you need to have more robust measures in place. So really interesting to see the ICO focusing on those riskier areas, which I think kind of very much dovetails with their enforcement strategy as well. I want to touch on direct marketing guidance, which Vicky has already mentioned as well. And the reason is that this is such an important area for charities, because fundraising and promotion of aims and ideals counts as direct marketing. The ICO recently updated their direct marketing guidance. And they've now created quite a useful hub on their website where they've pulled together all of the direct marketing guidance, because previously it was slightly scattered around the website, which made it a little bit more difficult for us to find where these things were. Interestingly, the ICO actually are required under the Data Protection Act to do a code of practice on direct marketing. And we did see a draft of that code of practice back in March, I think it was early 2020. And then there was a consultation on that as well, which closed in March 2020. The latest that I've heard from the ICO is that they haven't finalised that code of practice yet because of the upcoming changes to data protection law, which I'm going to cover later on today. But just to kind of reassure you, their guidance is there, it's on the website, and they've now all kind of pulled it all together. And as Vicky said, it's a really important area for charities. So I do recommend having a look at that guidance if you haven't already. And then last but not least, I want to touch on information security and how the ICO kind of tackles their guidance in that area. So whilst the ICO do have information around things like encryption, information security, the measures that they expect you to put in place. So just as a kind of a brief reminder, you're expected to put into place appropriate technical and organizational measures to keep personal data secure. How you go about doing that is kind of your decision, and it will vary from charity to charity. But one of the key points for me is that over the last few years, we've really noticed that the ICO have been very much deferring to the National Cyber Security Centre and their guidance on anything cyber related. And actually, interestingly, if you look at ICO enforcement decisions as well, they will often judge an organisation by how well it complies with guidance that's put out there by the National Cyber Security Centre. So again, I would recommend that alongside looking at ICO guidance, which is really important for data protection compliance, your IT team in particular should very much be keeping up to date with the latest on best practice for keeping personal data secure from a cyber point of view as well. And the two do very much dovetail. And you can also get the impression from the ICO's guidance as well that they are probably in quite close communication with the National Cyber Security Centre as well. But that's all I wanted to say on this slide. So I'll move on to the next slide, please. Right, okay, so a large part of the work that I've been doing and a large part of the work that colleagues of mine have been doing over the last 5 years is around data subject rights requests. So by way of a little bit of a refresher, under the UK GDPR, individuals have various rights in their personal data. So this includes the right to make a subject access request, which is a right to obtain a copy of their personal data that your organisation is processing. And they're also entitled to certain supplementary information as well. So around the purposes for you processing it, how long you're planning to keep it for, what categories of recipients you've been sharing that data with, and information about the source of that data. So subject access request is definitely one of the most popular rights, and probably the right I will focus on the most this morning as well. But don't forget there are other rights in place under the UK GDPR too. Notably, we've got the right to erasure, which is essentially the right, it's sometimes known as the right to be forgotten. Now, this only applies in very limited circumstances. So if you need to keep data for genuine reasons, for example, you might need to defend legal claims, for example, that the right doesn't apply in that scenario. But the right to erasure is a right that we are seeing is slowly kind of increasing in how often it's being exercised. There's also a right called the right to rectification. And as the name suggests, that's to do with rectifying personal data. So we often see the right to rectification being made after someone's received a subject access request response, because they might spot in your response to them that data you hold about them is inaccurate or incomplete. So what they can do is they can say to you, no, I don't think that this data you hold about me is correct. Please, can you correct it? And then you would go ahead and you would check whether the data is correct. And if it's not, you'd correct it. Other rights include the right to object. Again, right to object, like the right to erasure, is very much not an absolute right. It only applies where you are relying on legitimate interests or public task as your lawful basis for processing. And again, it doesn't mean that you have to stop processing the individual's data if they make a right to object. You are still allowed to continue processing it, but you have to kind of do a balancing exercise and make sure that you are satisfied that you've got compelling legitimate reasons to continue processing the data. All staff should be aware of these rights because they can be exercised to anyone. And I'll talk about staff training in a moment. I think my advice to charities is you need to prepare to receive these requests. I'd be surprised if any of you haven't received at least a subject access request in the last 5 years. So the right to make a subject access request actually existed before the GDPR came in. It existed under the Data Protection Act 1998, but we have seen a phenomenal growth in the number of people making subject access requests. These are often made in the context of complaints, grievances. Sometimes people make them because they're genuinely just curious about what data you hold about them, but there's usually a reason. Now, whilst there might be a reason, that doesn't mean the person needs to give you a reason for making it. It's an absolute right that people have, and they don't need to explain to you or justify why they want to exercise the right, which it can be quite tricky because you can't really push back on the right being made. It's a fundamental right that people have under data protection law. So prepare to receive a request. So you should, for example, you should have staff training in place to make sure that all staff members know how to recognise these rights. And more importantly as well, that they shouldn't be dealing with them themselves. They should be passing the right or the correspondence, for example, to the person who will lead on the response. Now, one of the trickier things under the GDPR is that these rights can be made orally as well as in writing. So whilst under the old law, they could be made in writing, and you've got to charge £10 as well to deal with them. Under the GDPR, I think one of the reasons why we have seen such a phenomenal growth in people exercising their rights, particularly SARS, over the last 5 years, is because they're now free to make. Staff training is so critical when thinking about how you will respond to these rights. So, for example, when people have a right to request a copy of the personal data you hold about them, this can raise all sorts of challenges about how your charity has been processing data. So to give you an example, we do occasionally see, unfortunately, people writing inappropriate comments or unprofessional comments about people, which then sometimes have to be disclosed to the individual that's made the request. Because just because information is an opinion rather than factual doesn't mean it's not personal data. That's often a common myth out there sometimes. So make sure staff members know that anything they're recording needs to be absolutely professional. Staff training as well is really important around how staff members are storing data, because when you receive a right to erasure request or a subject access request for personal data, you need to be able to quite quickly and relatively easily put your hands on the data that needs to either be considered for erasure or prepared for disclosure under a subject access request. So think about what procedures you have in place and how staff at your charity are storing, filing personal data, because in my experience, the more organized you are with how you handle personal data, the easier it is to respond to these requests. Staff training as well is really vital around making sure that they understand that just because something might be held on a personal device, if they're using that personal device for work reasons, that doesn't mean it's not necessarily caught by a subject access request. So if you do allow staff members to, it's called bring your own device sometimes, isn't it? So if staff members are using their personal device legitimately for work reasons, that doesn't automatically mean it's exempt from disclosure under a SAR or falls outside the scope of a right to erasure request, for example. So again, coming back to this accountability point I was making earlier, you need to have procedures and policies in place to ensure your compliance with data protection law. One of the most challenging aspects sometimes of dealing with a SAR is doing proper searches. And in my experience of having dealt with probably hundreds of subject access requests now under the GDPR, it's the importance of thinking very clearly and quite tactically about how you are going to search for the personal data. So I've had clients come back to me in a bit of a panic saying that we've run a search across our system for this person's name, for example, because they thought that was the easiest way of finding their personal data. And it's come back with tens of thousands of, if not hundreds of thousands of emails. Because if an individual's been with you for a very long time, that could be the number of hits you get across their name. So my advice is think a little bit tactically about how you're doing the searches. Because just because somebody's name appears in a document doesn't mean it contains their personal data. So for example, if you have a staff member who makes a subject access request, and they've made quite a broad request, well, my first advice would be go back to them to try and clarify what they're after. But even after you've done that, and even after they may have clarified it, you still need to think quite clearly about how you're going to find their personal data. Just because somebody's CC'd into an email doesn't mean that email contains their personal data. So think about where you are most likely to find their personal data, which comes back to the point I was making a moment ago around how are you storing personal data? How are you filing it in a way that you are able to put your hands quite easily on the personal data you need to respond to a request? And then my final piece of advice, and this has been a bit of a whistle-stop tour, but these are some of the key things that I've noticed over the last few years really do make it easier to respond to these requests when you do receive them. Try and stick to your retention period. So under data protection law, you should only be keeping personal data for as long as you need it. Now, sometimes that can be a very, very long time, but often it's not. Like, how often do you need to, delete emails that really have no consequence whatsoever. I think these days we send so many emails that it means that you could be storing hundreds of thousands of emails on your system. And that's the data that's then being searched when you receive a rights request. So try and put measures in place to stick to the retention periods. As part of the accountability requirement, you should have something in place called a retention schedule, which ideally will outline for how long you need to keep different types of data, taking into account, for example, employment law for employee records, taking into account health and safety law for health and safety records, that kind of thing. So the more you can be organized about how you store your personal data, the easier it will be when people do exercise these rights. And I'm afraid, as I said, it doesn't look like they're going anywhere. I'll touch on some data protection reforms later, but I think so data requests and the other rights are very much here to stay. Next slide, please. Brilliant. I'll pass back to Vicky now to talk to you about top tips for avoiding a data breach.
Thanks, Claire. So there are various things that you can do to avoid a data breach, and I've mentioned earlier that not having technical and organisational measures is one of the biggest risks in terms of ICO fines. So there's a list there of sort of do's and do not things. But the first thing that I would encourage all organisations to do, regardless of size, if you're looking at your security measures, is carry out a risk assessment. And I've put there, do assess risks, mitigate risks, and that's part of this. Part of that is doing the risk assessment. And by doing a risk assessment, what I'm asking you to do is look at your particular organisation and work out where are you at risk. So in the case of HIV Scotland and Mermaids, for example, who got fines, part of their risk was that they didn't have procedures in place to help prevent emails being sent where they shouldn't be sent, or information being available on a website that shouldn't be available on a website. So if you have very sensitive information about individuals, that's a high risk, and you need to look at that. So you need to look at where is that stored, who has access to it, where are the weak links. And to be honest, what you are likely to find when you go through that process is that your weakest link are people, because we are human beings and we make mistakes, and mistakes happen. And with breaches, one of the key things that, because we do a lot of work on when a breach has happened and trying to put all the pieces together and put everything back in place. But actually, it's really important to do the work before a breach happens, to do everything that you can to prevent it, because the kinds of figures that we're looking at in terms of organisations that suffer a data breach, it's not if you suffer one, it's when will you suffer one. The most recent report by the government on data breaches reported, I think, because I'm doing this off the top of my head now, so I'm going to get the figures wrong, but it was something like 39% of organisations reported having had a data breach. Now, that's 39% of organisations who, one, knew that they had experienced a data breach, and two, were honest enough to report it. So the actual figure of organisations that have experienced a breach is much higher than that. That's what the experts are estimating. Because there will be situations where individuals have hacked into your system and they've been nosing around for months, and you may not even know because they haven't actually done anything about it yet. And that's always a risk. But it's generally speaking, a lot of the breaches, certainly that we see, are caused by an individual doing something that they actually shouldn't have done. And again, a lot of the breaches could have been prevented if staff had been adequately trained on spotting phishing emails, for example. And that's a really sort of basic thing that you can put in place. It won't ever be 100% effective, because I'm a lawyer, I work in data protection. I have sent an email to the wrong person more than once. We've all done it because it's really easy to do. So it's not that, so people aren't 100% perfect. So it won't prevent 100% of the breaches. But if you don't do any training, then everyone potentially is forwarding suspicious links all over the place. If you've done the training, you should, I think at the National Cybersecurity Centre say you could prevent 90% of breaches or something ridiculous. I don't know where they get that figure from, but apparently if you do train your staff and you do put in place some really basic sounding security measures, you can really prevent those types of breaches. So as I said, the first thing to do your risk assessment, assess the risks to your particular organisation, and work out what things you can put in place to mitigate those risks. And why I say risks to your particular organisation, because it is relevant, the types of data that you use. But you also need to think about yourself in terms of where you are in a supply chain. And this is quite important for charities, because quite often in the sector, you might be doing something relatively small with minimal personal data, for example, but you're working on a project with a government department, say, who's giving you some funding. Now, whilst your charity and your particular part of the project may not be high risk, the fact that you're part of a chain which involves, and so you're linked to a public authority or government department, places your risk higher, because an individual who's determined to get access to, let's say, the DFE or the whoever you have to be working with, they want to get access to their data, they may decide to go in through you, because your systems are now unlikely to be as sophisticated as a government department. Again, whether that is true in practice, I'm not going to comment, but that would be the theory. So it's important to look not just at your organisation just on its own, but also who are you working with, who are you partnering with, what software are you using, and all of those sorts of things to work out where your risks are. And then once you know what your risks are, then you can start to put in place things to mitigate them. And the top tip that I can give is training. And I've already mentioned that, Claire's spoken about that. If you train your staff and volunteers and anyone who is working on your systems in your basic procedures and some basic cybersecurity training, such as how to spot a suspicious link, what to do if you do spot one, etc., how to have a strong password, whatever your particular organisation's policy is on those, all of those sorts of things, and even down to locking your screen when you walk away from it. And I still see people not doing that. And it's one of those things that it's so ingrained in me that I'm working from home today, I'm in the house completely alone, I will still lock my screen when I go down to make a cup of coffee, because I just do. As soon as I stand up or go to stand up, it's just ingrained in me to do that. So not only do I do it at home where there's no risk, I also do it in the office where there's more of a risk, because there's more people running around, so people aren't looking over my shoulder and seeing what's on my screen, etc. So all of those sorts of things that are, to me, because I work in this area, they seem really obvious, but actually to somebody who's fresh into a new organisation, perhaps never done this type of work before, they may not, and they're not necessarily thinking about or having that, what a colleague used to call proportionate paranoia. Everybody's out to get me, so everyone's out to get into my system and look at my equipment and what I'm doing. So thinking about the very simple ways that you can stop that. So training on that. Policies are also really important. And one of the most recent large fines that was given to a company called Interserve, one of the key things that they had done wrong was they had some of their policies were inadequate. Where the policies were adequate, they didn't follow them. So they had some brilliant disaster recovery policies, and had they followed the policy around the types of investigation that they should have done when they had an initial breach, they would have discovered the second breach, which then caused a bigger loss. There's some technical stuff in there around what had been accessed, etc. But the point that the ICO was making was that it's no good, and Claire's made it under the accountability principle, it's no good having policies in place if you don't use them. It's no good having policies in place if they don't work, and it's no good not having policies in place at all, because then you've got nowhere to go if the worst happens. So making sure you've got those policies in place, that where you have them in place, that you update them on a regular basis, and you, as Claire mentioned, you stress test them. I mean, obviously, if you have a breach, that's the ideal time to stress test your policies, because then you see if they work. If they don't, change them. Ideally, run a test before that to see if they work, so that you can make those changes before you're doing it in real time. And record the measures that you're taking. And I can't stress this enough. And if you've got a risk assessment, it's likely it will be in there anyway. But it's all very well saying, again, under the accountability principle, it's not enough to just say, yes, we do training and we have policies and we do all of these great things and we're happy that we're compliant. How do you demonstrate that? Well, you demonstrate it by recording somewhere all of the steps that you're taking in order to mitigate these risks. And finally, consider undertaking the Cyber Essentials certification, which is run by the National Cybersecurity Centre that Claire mentioned earlier. They have, there's different levels. It's not recognised by the ICO as a certification, but it's essentially a set of guidance and principles that if you go through and you implement the things that they suggest, well, they say you can cut your risk of a breach by something like 90%. Again, I don't know how they've come to that figure or where that's come from, but it is things like looking at access controls, so who has access to what, and looking at training and policies, etc. So if you go through that framework, then that's one way of making sure that you've done everything that you can do to put in place to mitigate those risks. So things to avoid, generic training, although I'm going to talk to you about training in a second, but we saw a lot of this when the GDPR first came in. And a lot of organisations would buy into a general training that said, these are the principles of the GDPR, and the GDPR gives individuals a right of access and a right of this and a right of that, and that's great. But if you're talking to your staff, they don't understand how that applies to them. So by generic training, I mean, make sure you've got training that actually helps staff understand what they need to do day to day in order to comply. Don't ignore your policies. If you've got them, use them. If you don't have them, put them in place. Don't assume that security and data breaches are an IT issue. And I think that's the biggest danger. And we're all guilty of it, because part of preventing data breaches is around IT, and it is around firewalls and encryption. And that's the two things that I vaguely understand. So those are the two I always mention. But all of the IT software that you can put in place to help you with that, that's all great, and it's important, and it's part of the solution, but it's not the solution. And as I mentioned, actually individuals are likely to be your biggest risk area here, and you can't get a software, unfortunately, or you can't get software that will stop us being human and making mistakes. Don't fail to record the steps that you're taking, because again, under accountability, you'd still be in breach of data protection even if you had them in place and you didn't actually record and set out what you were doing. And don't fail to prepare. As I said right back at the beginning, it's not for all organisations now, it's not if we suffer a data breach, it's when we suffer, if you haven't already. So it's really important to make sure that you're thinking about this and putting things in place. Have the next slide, please. So I mentioned training. We do offer data protection e-learning for our charity clients. It's easy to set up. It provides you with evidence that staff have been trained, and that's really important for you in terms of accountability, and also making sure that you can catch the people that perhaps were away that particular day when you did the training. And the course includes an introduction to data protection and why it matters. It talks about sharing personal data and what you need to think about, and also looks at subject access requests and the rights of individuals. So it's generic in that it won't be tailored specifically to your organisation, but you can use it alongside your particular policies to inform staff. But what it is, it's that basic element that actually everybody in your charity is likely to need to know. I think we have a quick poll, Ellie, if you're interested in more details, and it's absolutely not a requirement, of course, please do let us know by just clicking yes, please, and we will get our team in touch with you about that. There's no requirement to sign up either if you request details. Our team who run this will just talk you through what it is and give you a demonstration so that you can see if it's something that would be helpful. Just give you a second to answer, and then we'll go back to Claire to talk about the bill.
Thanks, Vicky. Right, everyone, so very exciting time at the moment to be a data protection lawyer, and I just want to finish off today's session by talking about the new Data Protection and Digital Information Bill. So just by way of a little bit of background, the GDPR, you may recall, was a European law. When we left the European Union, when the transition period ended at the very end of 2020, the GDPR essentially got copied and pasted, is the technical term, into UK law as retained EU law, and some minor amendments were made so that it worked in a UK only context, and we now refer to it as the UK GDPR for that reason. The government is now thinking about updating the law. It's one of the kind of key pillars of its work around innovation and AI as well. The government's very keen on using and harnessing the power of AI. It's basically a kind of turbocharge the economy is the great plan, essentially. And data protection law is seen as part of that, because on the one hand, we absolutely need to keep the high standard of data protection law that we have in place. And we need to keep what's called our adequacy decision with the EU so that data can flow freely between the UK and the EU. But at the same time, because we have now left the European Union, it is now open to the UK Parliament to make some amendments to data protection law to essentially improve it, to make it, hopefully, to make it kind of more kind of user-friendly, I think is the idea behind the bill. So hopefully, you know, this will hopefully benefit charities in the ways that I'm about to outline. The bill was originally put before Parliament in July last year, and then it was due to have its second reading, which was its first debate really in Parliament at the very beginning of September. On the same day actually that Liz Truss was elected as leader of the Conservative Party. The bill was then kind of pulled by the Liz Truss administration, or the Liz Truss government. And since then, the government have been thinking about whether any further improvements could be made to it. And then on the 8th of March, so very, very recently, a second version of the bill was put before Parliament. And this is the version of the bill that I'll be talking about today. But I just wanted to set that scene really before kind of diving into the details of how this bill might affect you. Now, should say this bill has yet to be properly debated by Parliament. It still has to go through the House of Commons, the House of Lords, and all of the select committees and that kind of thing. So what I'm talking about today is very much the first draft, as it were. So it's possible that as it goes through Parliament, amendments will be made to it. And we just don't know at the moment how substantive those amendments might be, assuming there are any at all. First thing I wanted to talk about is something called the senior responsible individual. Now, at the moment, certain organisations are required to have a data protection officer. Now, for charities, you are not automatically required to have a data protection officer. The public sector are required to have a data protection officer. For charities, it's very much a judgment call about what type of processing you do. The data protection officer is replaced under the bill with someone called a senior responsible individual. And the test for having to have one of these has also been slightly changed. So under the current version of the bill, the organisation has to appoint a senior responsible individual if it is likely to be doing processing which is likely to lead to high risk to individuals. Now, you might recognise that test that I've just outlined because it's the same test as having to do a data protection impact assessment. So again, difficult to say at the moment, and this is an area where the ICO guidance would be really helpful, I think. But it's arguable at the moment that you will be required to have a senior responsible individual to manage data protection compliance if you do any processing that has required you to do a data protection impact assessment. Now, this senior responsible individual, the good news is that whilst they have to be part of the senior management of your organisation, they are allowed to get help with doing those tasks. So they are allowed to essentially delegate those tasks to somebody else to get support. It doesn't have to just be one individual doing all of this. Although the name of the senior responsible individual does have to be publicised and put in things like your privacy notices, I think, and told to the ICO. But as I said, they can, kind of the wording is that they can secure the tasks are performed by another person. So that doesn't mean that you have to be part of the senior management to be involved in your charity's data protection compliance. It's just that, assuming you are caught by this requirement to have a senior responsible individual, which you might not be depending on the processing you're doing, there has to be someone on your senior management as well. Now, in some ways, that's really good news because the ICO have been very clear that their view is that data protection compliance is a boardroom issue, as they call it. It is something that, you know, the trustees of your charity, for example, should be actively monitoring and involved in, because it is such a serious thing. You know, as Vicky's explained, you know, data breaches can have really serious consequences. As I said, this is just the first iteration of the bill, so it's very possible this will be tweaked, and we'll obviously keep you up to date as we can. But that's how the land lies at the moment regarding the senior responsible individual. The next thing to focus on is legitimate interests. So as you all know, I'm sure, when you process personal data, you need to find one of 6 lawful bases under the GDPR to process it. And legitimate interest is one of those 6. And it is quite often relied on by charities as well. Now, at the moment, when you rely on legitimate interests, you have to carry out a balancing exercise, because you can't rely on legitimate interests if your legitimate interest in using the data in the particular way you want to is outweighed by the individual's rights and freedom. So you're essentially balancing your legitimate interest against the individual's rights whenever you're choosing to rely on legitimate interests. That obviously is quite onerous, and the government are trying to make data protection law a bit more user-friendly, a bit more kind of business-friendly, as it were. So under the new bill, there is an annex which outlines certain processing activities or certain purposes for using personal data, which are deemed to be, and the wording is, recognised legitimate interests. In a charity context, I think one of the most useful recognised legitimate interest is if you are processing data to safeguard a vulnerable individual, which I know a lot of charities do. That's often the reason for your existence, isn't it? So that's really helpful. That might take some of the burden away when doing these legitimate interest assessments. The next point I want to cover relates to complaint handling. So the ICO receive a large number of complaints every year. The vast majority of these, according to the ICO stats I've seen, are in relation to subject access requests. I think that's probably because, as I said earlier, when people make a SAR, there's normally a background to it. There's normally a complaint or grievance in the background. So these are people that are already having a complaint, you know, about something or other. This is obviously incredibly burdensome for the ICO to deal with. They're dealing with tens of thousands of complaints a year. So what the bill does is it states that the ICO doesn't have to consider a complaint until the individual, the complainant, has gone through the organisation's own complaints procedure. So what this means for your charity is that if this bill does go through as it's currently drafted, you'll be required to put kind of measures in place to facilitate complaints. So a complaint form is mentioned in the bill as one of those things that you might be required to put in place to facilitate these complaints. At the moment, this is very much what the ICO are trying to do in practice anyway. So those of you that have received complaints from the ICO, you might have already found that the ICO essentially writes to you and says, we've received a complaint about X, Y, and Z, but before we're going to think about it, before we're going to spend much time on it, we're going to ask you to try and resolve things between yourselves. So essentially what the bill is doing is putting on a more formal footing what's already kind of being encouraged by the ICO at the moment. I mentioned records of processing activities earlier as one of the key parts of the accountability requirement, one of the key pieces of documentation you're required to have in place. There is a change under the bill to the requirement to have a record of processing activities. So under the current version of the bill, you are only required to have a record of processing activities if your organisation carries out processing likely to result in high risk to individuals. So it's that same test again, isn't it? The DPIA test, essentially. Do you need to have a senior responsible individual test? So that is something that the government were very keen on, because the government were quite conscious that smaller organisations, including small charities, are required to have in place at the moment a record of processing activities for the most part. There is a very limited exemption at the moment. If you do any special category processing, that exemption essentially doesn't apply to you. So this is probably one of the main changes actually around the accountability principle, that going forward, if the bill passes in its current form, it's possible you won't need to have a record of processing activities in place. And the final thing I wanted to touch on is something that I know is very much of interest to the charity sector, and that's the reforms around direct marketing. So as Vicky mentioned earlier, and as I touched on as well, at the moment, the privacy and electronic communication regulations mean that you need consent before sending fundraising materials to individuals by electronic means, so notably emails. There is an exemption to that at the moment, colloquially called the soft opt-in. But at the moment, the soft opt-in only applies where the organisation who wants to send the direct marketing has sent it to someone where it obtained the contact details of that individual, so the email address, for example, during the course of a sale or negotiations for a sale. So that doesn't really help charities where you might not have got the contact details during the course of a sale or negotiations for sale, but you might have got them, for example, because the individual expressed an interest in supporting you. What the bill does is it slightly extends the soft opt-in, and the devil is very much in the detail here, so I'm not going to go through it in too much detail. But the key is that it extends it so that you can rely on the soft opt-in. So just to recap, not get consent, but only if your direct marketing is to further a charitable objective, and you must have obtained the contact details in the course of the individual expressing an interest in or offering to provide support for that objective. And this is the absolute key, that they must have been given a simple means of refusing the direct marketing when you first collected their contact details. And again, at each subsequent communication as well. So whilst it's really helpful that this is putting kind of charitable direct marketing on the same footing as more commercial direct marketing, you do still have to have given the individual the opportunity to opt out at the point you've got their contact details as well. So it's not an absolute free-for-all, essentially. But this is, I think, a positive development. And I know it's something that the charity sector have been kind of campaigning for, as it were, for quite some time. There is probably quite a lot more in the bill, but those are the key points I wanted to focus on today. We'll obviously be keeping you up to date over the next few months as it goes through Parliament as well, so stay tuned. That's it for me. So I'll move on to the next slide now, which should be Vicky and I taking some questions. Vicky, while I have a quick look at the questions, would you mind?
Yeah, I'll jump in. So the first question is around a visitor has raised concern regarding our signing in books. They were happy to sign a paper book but refused to sign the new electronic book, as they believe we have not provided the correct information regarding the right to be informed. Can you explain what information we need to provide and how this is different from a paper version? Thanks. So the first answer is there is no difference in the information you have to provide. The right to be informed is essentially the right to receive a privacy notice. So everything that you have to put in a privacy notice is what you have to put in, what you have to tell people when they're signing into your electronic book, because they're giving you personal data, but you would have had to have given them exactly the same information, well, the same type of information when they were signing in on a paper book. The fact that it's electronic doesn't actually change anything. So it's what they're asking for is a privacy notice, essentially. The next question says, if someone changes their email address from one they've used regularly for the past 4 years, what are our responsibilities regarding the removal of the previous email address? Did you want to take that, Claire, around rights and...
Sorry, Vicky, I was reading another question at that point.
Sorry.
That's okay.
Do you want me to take it?
Would you mind? I'll do the next one.
Okay, no problem at all. Essentially, there's a number of issues sort of bubbling around here. That first of all, if you've got an old email address that's no longer valid, you no longer need that personal data unless you need it for another reason. Then my advice would be just delete it. Because it's of no use to you. If the individual specifically makes a request for you to erase it, you probably have to, depending on if it's necessary for other purposes. And finally, if they've made a request for rectification because your current email address, the old one, is incorrect, then you would have to change it to the new one. So it does sort of depend on what information they have, why you've got the email address, and whether it is actually potentially necessary for you to hold it for other purposes other than contacting them. But yeah, there is, if you no longer need the information, then you would get rid of it.
Brilliant, thanks, Vicky. So we've got a question here about WhatsApp groups, and this is a question I get quite a lot. So the question is, broadly speaking, the charity has a WhatsApp group for senior colleagues to communicate because it's often one of the easiest ways to communicate. It's on their personal mobiles, apparently. And the question is, would the WhatsApp messages be in scope for a subject access request? So the ICO's guidance on this is that you are not obliged to search people's personal devices or people's personal kind of WhatsApps unless you have good reason to believe that the personal data that's being requested is held there, because it would be quite privacy intrusive, wouldn't it? You know, if VWV received a subject access request and they asked me to hand over my personal mobile, that's quite privacy intrusive. So the question becomes, well, do you have good reason to believe that the personal data is held there? So I suppose the kind of very lawyerly answer is it very much depends. It depends whether you think that those individuals are using that WhatsApp chat for things that are work related and therefore could be within the scope of a subject access request that you receive. Coming back to things like accountability and also security as well, which Vicky's mentioned is the high risk area here. You know, if you are allowing individuals at your charity, whether they be senior or more junior, to process personal data on behalf of the charity using personal devices, using personal communication channels, then you are responsible for the security of that personal